Question 1. During a critical transition period where existing processes for patent applications are being updated to accommodate international treaties, a pharmaceutical company files a patent application for a new drug formulation in multiple jurisdictions, including the US, the European Union, and China. The company claims priority based on a provisional application filed in the US under the Paris Convention. However, a competitor challenges the patent in the EU, arguing that the US provisional application did not sufficiently describe the invention. Under international patent law principles and the requirements of sufficient disclosure, which of the following is the most accurate legal consequence of the challenge in the EU? The challenge is invalid because the Paris Convention ensures automatic recognition of priority without considering the content of the original filing. B. The challenge is valid because the sufficiency of disclosure is judged independently in each jurisdiction, and if the U.S. provisional application lacks necessary details, priority may not be recognized. C. The challenge is invalid because any deficiencies in the U.S. provisional application can be corrected through subsequent filings before the patent grant. D. The challenge is valid because priority claims under the Paris Convention apply only if the first filed application is granted a patent in its home jurisdiction. Answer B. The challenge is valid because the sufficiency of disclosure is judged independently in each jurisdiction, and if the U.S. provisional application lacks necessary details, priority may not be recognized. Explanation: the Paris Convention, 1883, provides a priority right, allowing applicants to file in other member states within 12 months while claiming priority from their initial filing. However, the priority claim is only valid if the first application adequately describes the invention. Article 4 of the Paris Convention. If the original U.S. provisional application fails to provide sufficient disclosure, the EU Patent Office may deny priority as sufficiency is judged independently under European Patent Convention, Article 83, requiring a sufficient disclosure for an invention to be reproducible. Option A is incorrect because priority is not automatic. A substantive examination still applies. Option C is incorrect because deficiencies in disclosure cannot be corrected retrospectively after the priority date. Option D is incorrect because the Paris Convention does not require the first filed application to result in a granted patent for priority to be valid. Question 2. In a situation where formal requirements conflict with substantive patent law principles, a company files a patent application in the U.S. containing claims that appear overly broad. The USDO examiner issues a rejection based on lack of enablement under 35 U.S.C. SS, arguing that the specification does not sufficiently teach a person skilled in the art how to make and use the claimed invention. The applicant argues that some claims are valid because they are supported by prophetic examples rather than actual experimental data. Which of the following best explains the legal position regarding the use of prophetic examples in patent applications? A. Prophetic examples are always insufficient to satisfy the enablement requirement under 35 U.S.C. SS and cannot support patent claim. B. Prophetic examples can be used in patent application, but they must be clearly distinguished from working examples, and the specification must still enable the full scope of the claim. C. The presence of prophetic examples automatically satisfies the enablement requirement as long as they describe plausible scientific mechanism. D. Prophetic examples are only permissible in biotechnology, pharmaceutical patents, and are not applicable to other fields of technology. Answer B. Prophetic examples can be used in a patent application, but they must be clearly distinguished from working examples, and the specification must still enable the full scope of the claim. Explanation: under 35 U.S.C. SSA enablement requirement, an applicant must provide sufficient details for person skilled in the art for CETA to make and use the invention without undue experimentation. The Federal Circuit has upheld that prophetic examples are permissible if they are clearly labeled as hypothetical and still enable the full breadth of the claims. See in Re 1's 858 F. Toward 731 Fed. Sir. 1988. Option A is incorrect because prophetic examples can be valid if they meet enablement requirements. Option C is incorrect because mere plausibility does not satisfy enablement. The disclosure must allow replication. Option D is incorrect because prophetic examples are used across multiple fields, not just biotech. Question 3. While investigating a complicated issue between different claim interpretations in patent litigation, a court must determine whether an alleged infringer has violated a patent under the doctrine of equivalence, though The patent holder argues that although the infringing product does not literally infringe the claims, it performs substantially the same function in substantially the same way to achieve substantially the same result. The accused infringer counters that the patentee is stopped from making this argument due to amendments made during prosecution. Under U.S. patent law, which of the following is the most accurate explanation of how prosecution history estoppel limits the doctrine of equivalence? A. Prosecution history estoppel bars the application of the doctrine of equivalence only if the applicant made amendments related to patentability and surrendered claim scope. B. Prosecution history estoppel applies in all cases, preventing any claims of equivalence after amendments are made. C. The doctrine of equivalence is never affected by prosecution history estoppel, as courts focus solely on the technical similarities between the patent and accused product. D. Prosecution history estoppel only applies when an amendment is made due to a rejection under 35 U.S.C. SS. Novelty, and does not affect amendments made for clarity under 35 U.S.C. SS. Answer. A. Prosecution history estoppel bars the application of the doctrine of equivalence only if the applicant made amendments related to patentability and surrendered claim scope. Explanation. Under Festo Corp. v. Shoketsu Kinzoku Kogyo Kabushiki Company 535 U.S. 722, 2002. Prosecution history estoppel applies when an applicant narrows a claim scope to overcome rejection related to patentability, e.g. under 35 U.S.C. SS. Novelty or SS. Non-obviousness. This prevents the patentee from later recapturing the surrendered subject matter under the doctrine of equivalence. However, if the amendment was unrelated to patentability, such as clarification under SS, estoppel does not necessarily apply. Option B is incorrect because not all amendments trigger estoppel. Only those made for patentability reasons do. Option C is incorrect because prosecution history estoppel is recognized limitation on the doctrine of equivalence under Supreme Court and Federal Circuit precedent. Option D is incorrect because estoppel can apply beyond SS-based amendments, including those made under SS for obviousness. Question 4. In a high-stakes environment where multiple challenges arise due to conflicting international patent laws, a pharmaceutical company seeks to file a patent for a groundbreaking cancer treatment. The company has already filed a U.S. patent application and is now considering global expansion, particularly in the European Union and China. However, the drug's formulation was disclosed in a research journal 6 months before the initial filing. Under U.S. patent law, a one-year grace period exists for such disclosures, but the European Patent Office, EPO, and China follow an absolute novelty standard where any prior disclosure invalidates patentability. Given these variations in patent law, how should the pharmaceutical company proceed to maximize its patent rights internationally? A. File a Patent Cooperation Treaty (PCT) application to secure an international priority date and rely on the U.S. grace period for all jurisdictions. B. Abandon efforts in Europe and China and focus solely on U.S. patent protection due to the prior disclosure. C. Challenge the novelty rejection in Europe and China by arguing that the disclosure was made by the inventor and should not count as prior art. D. File for patents in jurisdictions that recognize the U.S. grace period while seeking alternative IP protections, such as trade secrets in absolute novelty jurisdictions. Answer. D. File for patents in jurisdictions that recognize the U.S. grace period while seeking alternative IP protections, such as trade secrets in absolute novelty jurisdictions. Explanation. Patent laws vary significantly across jurisdictions. The U.S. applies a one-year grace period, 35 U.S.C. SS 102b(1), allowing inventors to file for patent even if they publicly disclose their invention. However, the European Patent Office, EPO, and China operate under an absolute novelty standard, meaning any prior public disclosure invalidates patentability. Article 54 Chinese Patent Law. Article 22. Option is incorrect because the PCT system does not override national patent laws regarding prior art. Each jurisdiction still applies its own rules. Option B is incorrect because international IP strategy should not be abandoned outright. Alternative protections should be explored. Option C is incorrect because EPO and China do not recognize an inventor's own disclosure exceptions in this case. Thus, option D is correct. The company should file in grace period jurisdictions and explore trade secrets or regulatory protections elsewhere. Question 5. During an emergency response where multiple areas are impacted by a patent infringement lawsuit, A small biotech company is accused of violating a larger competitor's patent on gene editing technology. The small company argues that its method is sufficiently different and invokes the doctrine of equivalence to claim non-infringement. The plaintiff, however, counters by citing prosecution history estoppel, stating that during the application process, the defendant made amendments that limit their ability to argue for equivalence. What legal principles should be considered in determining the outcome of this case? A. The doctrine of equivalence allows the biotech company to argue non-infringement if their method performs the same function in substantially similar way. B. Prosecution history estoppel bars the defendant from using the doctrine of equivalence if they previously narrowed their patent claims to secure approval. C. The biotech company can invoke prior user rights under patent law to continue using their technology despite the infringement claims. Patent exhaustion applies, meaning once the plaintiff's patented product is sold, downstream users are free to use it however they wish. Answer: B. Prosecution history estoppel bars the defendant from using the doctrine of equivalence if they previously narrowed their patent claims to secure approval. Explanation: the doctrine of equivalence, Warner Jenkinson, Umpany v. Hilton Davis Chem, Umpany 520 U.S. 17, 1997, allows a patent holder to claim infringement even if the accused product or process does not literally infringe the patent but performs substantially the same function in substantially the same way to achieve the same result. However, prosecution history estoppel Festo Corp. v. Shokatsu Kinzoku Kogyo Kabushiki Company 535 U.S. 722, 2002 limits this doctrine. If a patentee narrows a claim to obtain a patent, they cannot later argue that the surrendered subject matter falls under the doctrine of equivalence. Option is incorrect because while the doctrine of equivalence exists, prosecution history estoppel can bar its use. Option C is incorrect because prior user rights are rare in U.S. patent law and are primarily a defense under 35 U.S.C. SS 273 for certain business methods. Option D is incorrect because patent exhaustion applies to downstream users, not competing biotech firms developing similar technology. Thus, option B is correct. If the biotech firm previously narrowed their claims, they cannot later broaden them via the doctrine of equivalence. Question 6. While investigating a complicated issue between different entities holding overlapping patent rights in artificial intelligence (AI), a technology startup is accused of patent infringement by a major AI corporation. The startup argues that its use of AI technology falls under fair use and open source principles. The corporation claims that the startup's AI model incorporates proprietary patented algorithms. Under U.S. patent law, how should the court evaluate this dispute? A. The startup can claim fair uses, a defense because AI innovations are public knowledge and widely shared. B. If the corporation's patents are on fundamental AI principles, they may be invalidated under 35 U.S.C. SS 101 for lack of patent-eligible subject matter. C. The startup must license the patents because AI algorithms are always considered patentable intellectual property. D. The doctrine of patent misuse allows the startup to continue using the technology without legal repercussions. Answer: B. If the corporation's patents are on fundamental AI principles, they may be invalidated under 35 U.S.C. SS 101 for lack of patent-eligible subject matter. Explanation: AI-related patents must satisfy the patentability requirements under 35 U.S.C. SS 101. Recent court rulings: Alice Corp. v. CLS Bankint or 573 U.S. 208, 2014 have made it difficult to patent abstract ideas, including certain software and AI innovations. If the corporation's patent claims cover fundamental mathematical algorithms rather than specific technological applications, they could be invalidated. Option is incorrect because fair use is copyright defense, not patent defense. Option C is incorrect because not all AI algorithms are patentable as similar abstract ideas. Option D is incorrect because patent misuse is narrow defense against anti-competitive behavior, not general defense against infringement. Thus, option B is correct. If the AI patents are too abstract, they may be invalidated under 35 U.S.C. SS 101. Question 7. In a high-stakes environment where multiple challenges arise due to conflicting international patent laws, a pharmaceutical company seeks to file a patent for a groundbreaking cancer treatment. The company has already filed a U.S. patent application and is now considering global expansion, particularly in the European Union and China. However, the drug's formulation was disclosed in a research journal 6 months before the initial filing. Under U.S. patent law, a one-year grace period exists for such disclosures, but the European Patent Office, EPO, and China follow an absolute novelty standard where any prior disclosure invalidates patentability. Given these variations in patent law, how should the pharmaceutical company proceed to maximize its patent rights internationally? File a patent cooperation treaty (PCT) application to secure an international priority date and rely on the U.S. grace period for all jurisdictions. B. Abandon efforts in Europe and China and focus solely on U.S. patent protection due to the prior disclosure. C. Challenge the novelty rejection in Europe and China by arguing that the disclosure was made by the inventor and should not count as prior art. D. File for patents in jurisdictions that recognize the U.S. grace period while seeking alternative IP protections, such as trade secrets in absolute novelty jurisdictions. Answer D. File for patents in jurisdictions that recognize the U.S. grace period while seeking alternative IP protections, such as trade secrets in absolute novelty jurisdictions. Explanation: patent laws vary significantly across jurisdictions. The U.S. applies a one-year grace period, 35 U.S.C. SS 102b(1), allowing inventors to file for patent even if they publicly disclose their invention. However, the European Patent Office, EPO, and China operate under an absolute novelty standard, meaning any prior public disclosure invalidates patentability at Article 54 Chinese patent law. Article 22. Option is incorrect because the PCT system does not override national patent laws regarding prior art. Each jurisdiction still applies its own rules. Option B is incorrect because international IP strategy should not be abandoned outright. Alternative protections should be explored. Option C is incorrect because EPO and China do not recognize an inventor's own disclosure exceptions in this case. Thus, option D is correct. The company should file in grace period jurisdictions and explore trade secrets or regulatory protections elsewhere. Question 8. During an emergency response where multiple areas are impacted by a patent infringement lawsuit, a small biotech company is accused of violating a larger competitor's patent on gene editing technology. The small company argues that its method is sufficiently different and invokes the doctrine of equivalence to claim non-infringement. The plaintiff, however, counters by citing prosecution history estoppel, stating that during the application process, the defendant made amendments that limit their ability to argue for equivalence. What legal principles should be considered in determining the outcome of this case? A. The doctrine of equivalence allows the biotech company to argue non-infringement if their method performs the same function in substantially similar way. B. Prosecution history estoppel bars the defendant from using the doctrine of equivalence if they previously narrowed their patent claims to secure approval. C. The biotech company can invoke prior user rights under patent law to continue using their technology despite the infringement claims. Patent exhaustion applies, meaning once the plaintiff's patented product is sold, downstream users are free to use it however they wish. Answer: B. Prosecution history estoppel bars the defendant from using the doctrine of equivalence if they previously narrowed their patent claims to secure approval. Explanation: the doctrine of equivalence, Warner Jenkinson, Umpany v. Hilton Davis Chem, Umpany 520 U.S. 17, 1997, allows a patent holder to claim infringement even if the accused product or process does not literally infringe the patent but performs substantially the same function in substantially the same way to achieve the same result. However, prosecution history estoppel Festo Corp. v. Shokatsu Kinzoku Kogyo Kebushiki Company 535 U.S. 722, 2002 limits this doctrine. If the patentee narrows a claim to obtain a patent, they cannot later argue that the surrendered subject matter falls under the doctrine of equivalence. Option is incorrect because while the doctrine of equivalence exists, prosecution history estoppel can bar its use. Option C is incorrect because prior user rights are rare in U.S. patent law and are primarily a defense under 35 U.S.C. SS 273 for certain business methods. Option D is incorrect because patent exhaustion applies to downstream users, not competing biotech firms developing similar technology. Thus, option B is correct. If the biotech firm previously narrowed their claims, they cannot later broaden them via the doctrine of equivalence. Question 9. In an environment where corporate governance is increasingly scrutinized, a multinational technology firm is accused of failing to disclose critical cybersecurity risks to its investors. The company argues that it complied with its disclosure obligations under securities laws, but regulators claim that its omissions misled shareholders about vulnerabilities that were later exploited in a major data breach. Under U.S. securities regulations, how should this case be evaluated? A. The company is liable under the Securities Exchange Act of 1934 if it made misleading omissions that a reasonable investor would consider material. B. The company is not liable because cybersecurity risks are speculative and not required to be disclosed unless they result in an actual financial loss. C. The company is only liable if there is evidence of intentional fraud, scienter, rather than mere negligence in failing to disclose. D. The company can avoid liability if it had a general disclaimer about cybersecurity threats in its risk disclosures. Answer A. The company is liable under the Securities Exchange Act of 1934 if it made misleading omissions that a reasonable investor would consider material. Explanation. Under the Securities Exchange Act of 1934, companies must disclose material risks to investors. The Supreme Court's test for materiality, Basic Inc. v. Levinson, 485 U.S. 224, 1988, states that information is material if there is substantial likelihood that reasonable investor would consider it important in making an investment decision. The SEC has emphasized that cybersecurity risks are material if they could reasonably impact companies' operations or financial performance. SEC Rule 10.5, 17c, F. SS 240.105. Option B is incorrect because companies must disclose risks even if they have not yet resulted in financial loss. Option C is incorrect because scienter, intent to deceive, is required for fraud claims, but not for general disclosure violations. Option D is incorrect because generic risk disclosures do not absolve liability if specific known risks were omitted. Thus, option is correct. If the company's omissions misled investors about cybersecurity threats, it could face SEC enforcement. Question 10. During a regulatory compliance audit where corporate officers are under scrutiny, a financial institution is found to have engaged in discriminatory lending practices violating the Equal Credit Opportunity Act (ECOA). The company argues that the disparities in loan approvals were due to neutral business factors rather than discrimination. How should regulators determine whether the institution violated ECOA? A. Regulators should evaluate whether there is direct evidence of intentional discrimination in the company's lending policies. B. Regulators can establish violation if there is disparate impact on protected classes, even without direct intent to discriminate. C. The financial institution can defend itself if it can prove that the disparities were due to factors unrelated to race, gender, or other protected characteristics. D. ECOA violations apply to mortgage lending, so the financial institution would not be liable for discriminatory practices in personal loans. Answer B. Regulators can establish a violation if there is a disparate impact on protected classes, even without direct intent to discriminate. Explanation. The Equal Credit Opportunity Act (ECOA) 15 U.S.C. SS 1691 et seq. prohibits lending discrimination based on race, color, religion, national origin, sex, marital status, or age. Regulators apply both disparate treatment, intentional discrimination, and disparate impact, facially neutral policies that disproportionately harm protected groups. In Texas Department of Housing and Community Affairs v. Inclusive Communities Project Inc. 576 U.S. 519 2015, the Supreme Court upheld disparate impact as valid basis for finding discrimination even without intent. Option is incorrect because a code does not require direct evidence of intent. Disparate impact is sufficient. Option C is incorrect because even if neutral factors were used, they cannot justify policies that disproportionately harm protected classes. Option D is incorrect because ECOA applies broadly to all types of credit, not just mortgages. Thus, option B is correct. Disparate impact alone can establish violation even in the absence of intent. Question 11. Under a legislative framework where labor unions and employers negotiate collective bargaining agreements, a dispute arises between a national airline and its pilots' union over changes to retirement benefits. The airline unilaterally implemented the changes, arguing that they were necessary for financial stability. The union claims this violated the National Labor Relations Act (ARO). What key legal issues must be considered? A. The airline was within its rights because financial necessity allows unilateral changes without union approval. B. The airline violated the ARA by failing to bargain in good faith over mandatory subjects of bargaining. C. The pilots' union cannot challenge the changes unless they have exhausted all internal grievance procedures. D. The airline's actions are legal if the changes were applied equally to all employees, not just union members. Answer. B. The airline violated the ARA by failing to bargain in good faith over mandatory subjects of bargaining. Explanation. Under the National Labour Relations Act Area 29 U.S.E. SSS 151-169, employers must bargain in good faith over wages, hours, and other terms of employment. The Supreme Court in NLRB v. Katz 369 U.S. 736, 1962, held that employers cannot unilaterally change mandatory bargaining subjects without negotiating with the union. Option is incorrect because financial necessity does not override collective bargaining obligations. Option C is incorrect because the union can challenge violations through the National Labour Relations Board (NLB) regardless of internal grievance procedures. Option D is incorrect because even if changes apply to all employees, they still require bargaining. Thus, option B is correct. The airline violated the ARA by failing to negotiate changes to retirement benefits. Question 12. In a regulatory environment where financial institutions are expected to prevent money laundering, a multinational bank is found to have failed in its obligations under the Bank Secrecy Act (BSA). The bank claims that it was unaware of suspicious transactions flowing through its accounts. What legal standards apply to determine its liability? A. The bank is only liable if there is evidence that its executives knowingly facilitated money laundering. B. The bank is liable under the BSA if it failed to implement adequate anti-money laundering ML controls, regardless of intent. C. The bank can only be penalized if it received a formal warning from regulators before the violations occurred. D. Financial institutions are exempt from liability if they rely on third-party vendors for ML compliance. Answer. B. The bank is liable under the BSA if it failed to implement adequate anti-money laundering ML controls, regardless of intent. Explanation. The Bank Secrecy Act BSA 31 U.S.C. SSS 5-311-5330 requires financial institutions to establish AML programs, report suspicious activities, and maintain records of financial transactions. Failure to implement adequate AML controls can lead to civil and criminal penalties even without direct knowledge of wrongdoing. Option is incorrect because liability can arise from inadequate compliance, not just willful misconduct. Option C is incorrect because regulators do not need to issue prior warning for penalties to apply. Option D is incorrect because banks remain responsible for compliance even if they outsource AML functions. Thus, option B is correct. Banks are liable under the BSA if they fail to implement adequate AML controls, regardless of intent. Question 13. Given a corporate setting where data privacy is a major concern, the social media company collects and processes vast amounts of user data without obtaining explicit consent. A regulatory agency investigates the company for potential violations of data protection laws. What legal principles should be applied to determine compliance? A. The company is only liable if it sold user data to third parties without permission. B. The company is in violation if it failed to obtain informed consent for data collection and processing. C. The company can argue that by using the platform, users implicitly consented to data collection. D. The company is exempt from liability if it provides a general disclaimer about data collection in its terms of service. Answer. B. The company is in violation if it failed to obtain informed consent for data collection and processing. Explanation. Under data protection laws like the General Data Protection Regulation (EDR) at the California Consumer Privacy Act (CPA), organizations must obtain explicit informed consent before collecting or processing personal data. Option is incorrect because liability extends beyond selling data. Failure to obtain consent is enough to constitute violation. Option C is incorrect because implicit consent is not sufficient under modern data privacy laws. Option D is incorrect because disclaimers alone do not satisfy informed consent requirements. Thus, option B is correct. The company must obtain clear informed consent before processing user data. Question 14. As part of an international business expansion, a pharmaceutical company enters into contracts with foreign suppliers. However, reports emerge that one of its key suppliers uses forced labor in its supply chain. What legal and ethical obligations does the company have? A. The company has no liability unless it directly employs forced labor. B. The company must conduct due diligence and can face liability if it only benefits from forced labor. C. The company is only liable if it received a direct complaint from workers in the affected factories. D. There is no legal requirement to investigate suppliers unless a government agency initiates an inquiry. Answer. B. The company must conduct due diligence and can face liability if it knowingly benefits from forced labor. Explanation. Under laws like the U.S. Tariff Act 19 U.S.C. SS 1307 and the UK Modern Slavery Act, companies must ensure that their supply chains are free from forced labor. Failure to conduct due diligence can lead to import bans, fines, and reputational damage. Option is incorrect because companies can be held liable if they benefit from forced labor, even indirectly. Option C is incorrect because liability exists even without direct complaint. Option D is incorrect because companies are required to proactively investigate and disclose risks in their supply chains. Thus, option B is correct. Companies must conduct due diligence to avoid benefiting from forced labor. Question 15. In an environment where corporate leadership is under increasing scrutiny, a board of directors must decide whether to disclose internal investigations into executive misconduct. What fiduciary duties must the board consider in making this decision? A. The board must prioritize protecting executives from reputational harm over shareholder transparency. B. The board has a duty to act in the best interests of shareholders and disclose material risks. C. The board can withhold information indefinitely as long as no laws were violated. D. The board should only disclose the investigation if it results in criminal charges. Answer. B. The board has a duty to act in the best interests of shareholders and disclose material risks. Explanation. Corporate boards have a fiduciary duty of care and loyalty to shareholders. Under SEC disclosure rules, Regulation SK, Item 303, material risks must be disclosed if they could impact the company's financial health or reputation. Option is incorrect because protecting executives is not valid reason to withhold material information. Option C is incorrect because companies must disclose material risks even if no laws were violated. Option D is incorrect because investigations may still be material even without criminal charges. Thus, option B is correct. The board must act in shareholders' best interests and disclose material risks. Question 16. During an earnings call where corporate officers discuss financial performance, 84A statements about projected revenue growth that turn out to be highly inaccurate. Shareholders later sue, alleging securities fraud. What legal standard will courts use to evaluate the CFO's statements? A. The company is liable if the CFO knowingly made false statements or acted with reckless disregard for the truth. B. The company is not liable unless the CFO explicitly stated that the revenue projections were guaranteed. C. The company can defend itself if the CFO provided general disclaimer about forward-looking statements. D. The company is only liable if shareholders can prove they relied on the CFO's statements when investment decisions. Answer. A. The company is liable if the CFO knowingly made false statements or acted with reckless disregard for the truth. Explanation. Under SEC Rule 10.5.17 CF SS 240.10.5, corporate officers can be liable for material misstatements or omissions made with scienter, intent, or reckless disregard for the truth. Option B is incorrect because fraud liability does not require an explicit guarantee. Misleading statements are sufficient. Option C is incorrect because disclaimers do not shield companies from liability if statements were knowingly false or misleading. Option D is incorrect because reliance is only required in private lawsuits, not SEC enforcement actions. Thus, option is correct. The company can be liable if the CFO knowingly or recklessly misled investors. Question 17. In a regulatory environment where financial institutions must report suspicious transactions, a cryptocurrency exchange is investigated for failing to comply with anti-money laundering (AML) regulations. What are the potential legal consequences? A. The exchange can face civil and criminal penalties if it failed to report suspicious transactions. B. The exchange is only liable if customers were explicitly warned about AML regulations. C. The exchange is not liable because cryptocurrency transactions are decentralized and difficult to monitor. D. The exchange can avoid liability by arguing that AML regulations do not apply to digital assets. Answer A. The exchange can face civil and criminal penalties if it failed to report suspicious transactions. Explanation. Under the Bank Secrecy Act (BSA) and the Financial Crimes Enforcement Network (FinCEN) regulations, cryptocurrency exchanges must implement AML programs and report suspicious transactions. Non-compliance can result in civil penalties, criminal charges, and regulatory enforcement actions. Option B is incorrect because AML compliance is mandatory regardless of customer awareness. Option C is incorrect because regulators have clarified that crypto transactions are subject to AML laws. Option D is incorrect because FinCEN classifies cryptocurrency exchanges as money service businesses (MABS), requiring compliance. Thus, option is correct. Cryptocurrency exchanges must comply with ML laws or face legal consequences. Question 18. When considering corporate social responsibility in a highly competitive industry, a major retailer is accused of engaging in greenwashing by falsely claiming that its products are environmentally friendly. What legal and reputational risks does the company face? A. The company can face liability under consumer protection laws if its environmental claims are misleading. B. The company is not liable if it intended to promote sustainability, even if the claims were inaccurate. C. The company can avoid liability if it includes a disclaimer that environmental claims are subjective. D. The company's actions are legal as long as no direct financial harm occurred to consumers. Answer A. The company can face liability under consumer protection laws if its environmental claims are misleading. Explanation. Under the Federal Trade Commission FTC Green Guides 16C F-bar, Part 260, misleading environmental claims are considered deceptive advertising. Companies can face FTC enforcement actions, fines, and reputational damage. Option B is incorrect because intent does not excuse false advertising. Option C is incorrect because disclaimers do not protect companies from false advertising liability. Option D is incorrect because consumer protection laws do not require financial harm. Deception alone is sufficient, thus option is correct. False environmental claims can lead to legal and reputational consequences. Question 19. When dealing with a complex system that shows occasional failures in high-risk situations, a financial institution notices anomalies in its automated fraud detection system. Despite passing internal tests, the system occasionally flags legitimate transactions as fraudulent while missing actual fraud cases. What should be the company's primary course of action to maintain compliance and minimize risk? A. Increase the threshold for fraud detection, reducing false positives at the cost of more false negatives. B. Conduct an independent audit and validate the algorithm against real-world fraud patterns. C. Shut down the system until all errors are eliminated to prevent potential financial harm. D. Rely on manual transaction reviews to compensate for the system's inconsistencies. Answer. B. Conduct an independent audit and validate the algorithm against real-world fraud patterns. Explanation. Financial institutions must comply with regulations like the Bank Secrecy Act (BSA) and anti-money laundering (AML) laws, ensuring that fraud detection systems are accurate, transparent, and explainable. Option is incorrect because increasing thresholds may reduce false positives but will also allow more fraud to slip through, violating compliance standards. Option C is incorrect because completely shutting down the system could expose the institution to legal and financial risks. Option D is incorrect because manual reviews are inefficient and cannot scale effectively. Thus, option B is correct. The company should conduct an independent audit and fine-tune the system to improve fraud detection accuracy. Question 20. During a comprehensive review of a process that needs improvement, a technology firm discovers that its software licensing agreements are outdated, creating legal ambiguities for customers using the product in multiple countries. How should the company proceed to ensure compliance? A. Apply the most restrictive licensing terms across all jurisdictions. B. Work with legal experts to update agreements in alignment with regional laws. C. Allow customers to continue using the outdated agreements until legal action forces a change. D. Provide a disclaimer stating that customers are responsible for understanding local licensing laws. Answer. B. Work with legal experts to update agreements in alignment with regional laws. Explanation. Software licensing is governed by intellectual property law (GDR) for data processing and regional software distribution regulations. Option is incorrect because overly restrictive terms may drive customers away and lead to compliance conflicts. Option C is incorrect because proactively addressing legal issues is crucial to avoid penalties. Option D is incorrect because companies cannot shift legal responsibilities entirely onto customers. Thus, option B is correct. The company must update agreements in compliance with regional regulations. Question 21. In an environment where different components must interact seamlessly, a healthcare provider is integrating a new electronic health records (EA) system but encounters compatibility issues with existing infrastructure. What is the best approach to maintain regulatory compliance and operational efficiency? A. Delay the rollout until all compatibility issues are resolved. B. Implement a phased integration with safeguards to protect patient data. C. Disable legacy systems entirely to force a complete transition. D. Allow departments to choose whether to adopt the new system or continue using the old one. Answer. B. Implement a phased integration with safeguards to protect patient data. Explanation. Healthcare providers must comply with HIPAA, Health Insurance Portability and Accountability Act, to ensure patient data security and system integrity. Option is incorrect because delaying indefinitely could disrupt patient care. Option C is incorrect because disabling legacy systems abruptly may cause data loss and compliance violations. Option D is incorrect because inconsistent system use creates data silos and regulatory risks. Thus, option B is correct. A phased integration with security safeguards ensures compliance and smooth adoption. Question 22. In a high-stakes environment where multiple challenges must be addressed simultaneously, a manufacturing company faces regulatory scrutiny after a safety audit reveals non-compliance in several areas. How should the company prioritize corrective actions? A. Address the most visible violations first to minimize reputational damage. B. Implement an organization-wide safety overhaul even if it temporarily disrupts production. C. Focus on addressing violations with the highest legal and financial risks first. D. Challenge the audit results and delay corrective measures while gathering more data. Answer. C. Focus on addressing violations with the highest legal and financial risks first. Explanation. Regulatory compliance in manufacturing is governed by OSHA Occupational Safety and Health Administration and other industry-specific laws. Option is incorrect because visibility does not determine legal risk. Option B is incorrect because a complete overhaul may be impractical and cause unnecessary disruptions. Option D is incorrect because delaying corrective actions increases regulatory penalties, thus option C is correct. Prioritizing high-risk compliance violations is the best strategy. Question 23. When implementing backup procedures across various departments, a financial services firm must ensure uninterrupted access to client data during system failures. What is the most effective strategy? A. Store client data backups in a single highly secure data center. B. Implement geographically distributed backups with regular integrity testing. C. Allow employees to manually back up important data on local devices. D. Prioritize speed over redundancy by keeping only the latest version of each file. Answer. A. Store client data backups in a single highly secure data center. Explanation. Financial firms must comply with SEC and FINRA regulations regarding data security, redundancy, and disaster recovery. Option is incorrect because a single location creates a single point of failure. Option C is incorrect because manual backups lack security and consistency. Option D is incorrect because older versions may be needed for audits or regulatory compliance. Thus, option B is correct. Geographically distributed backups ensure reliability and compliance. Question 24. During an emergency response where multiple areas are impacted, a multinational corporation faces a cybersecurity breach affecting its customer databases across different regions. What is the best immediate action? A. Notify all customers immediately, even before understanding the full impact. B. Conduct a preliminary forensic analysis to assess the scope and affected data. C. Shut down all systems to prevent further breaches, regardless of operational disruptions. D. Issue a legal statement denying responsibility until further investigation is complete. Answer. B. Conduct a preliminary forensic analysis to assess the scope and affected data. Explanation. Under data protection laws DPA, companies must assess breaches before issuing notifications. Option is incorrect because premature notifications can cause panic and misinformation. Option C is incorrect because shutting down all systems can cause more harm than good. Option D is incorrect because issuing denials before an investigation can damage credibility. Thus, option B is correct. Conducting a forensic analysis ensures an informed response. Question 25. While analyzing the root causes of sequential problems in a supply chain, a global retailer notices that delivery delays are becoming more frequent despite optimizing individual segments of the process. What is the most effective strategy to address the issue? A. Improve the performance of the slowest segment to balance overall efficiency. B. Conduct a system-wide analysis to identify bottlenecks and dependencies. C. Reduce reliance on third-party logistics providers and bring operations in-house. D. Increase order volume to compensate for potential future delays. Answer: B. Conduct a system-wide analysis to identify bottlenecks and dependencies. Explanation: supply chain efficiency is influenced by interdependencies, not just isolated performance improvements. Option is incorrect because fixing only the slowest segment does not address systemic inefficiencies. Option C is incorrect because bringing operations in-house is costly and may not address the root cause. Option D is incorrect because increasing order volume without addressing bottlenecks could worsen delays. Thus, option B is correct. A holistic system-wide analysis identifies interdependent weaknesses and allows for targeted, effective interventions. Question 26. In a multi-location scenario where consistency requirements must be maintained, a company rolling out a standardized customer service protocol finds that regional offices are interpreting the guidelines differently. What is the best approach to ensure uniform implementation? A. Provide extensive training and enforce strict adherence to a central script. B. Allow regional managers to adjust protocols based on local customer preferences. C. Establish a feedback loop where regional teams can suggest improvements while maintaining core guidelines. D. Implement an automated system that eliminates variations in service delivery. Answer: C. Establish a feedback loop where regional teams can suggest improvements while maintaining core guidelines. Explanation: standardization is important, but rigid enforcement can ignore local nuances and complete flexibility compromises consistency. Option is incorrect because overly strict adherence may reduce employee adaptability to real customer needs. Option B is incorrect because excessive customization could dilute brand consistency. Option D is incorrect because automating service delivery removes human adaptability, which is key in customer interactions. Thus, option C is correct. A structured feedback loop balances consistency with local adaptability, improving both customer satisfaction and operational alignment. Question 27. During a major transformation where existing methods are being replaced and a company shifting to a cloud-based infrastructure encounters resistance from employees who are comfortable with legacy systems, what is the best strategy to manage the transition smoothly? A. Mandate immediate adoption and discontinue legacy systems to force compliance. B. Provide structured training and a transition period to allow employees to adapt. C. Allow employees to decide whether they want to switch to the new system. D. Delay the transition until all employees express readiness for the change. Answer: B. Provide structured training and a transition period to allow employees to adapt. Explanation: adopting new technology requires both technical and cultural adaptation. Option is incorrect because forcing change too quickly leads to resistance and productivity loss. Option C is incorrect because parallel systems can create inefficiencies and inconsistencies. Option D is incorrect because delaying indefinitely reduces competitiveness and prolongs inefficiencies. Thus, option B is correct. A structured transition plan with training ensures smoother adoption and reduces resistance. Question 28. When improving a process that shows unexpected results, a pharmaceutical company conducting clinical trials finds that different test sites report varying effectiveness for a new drug. How should the company proceed to ensure accurate results? A. Disregard inconsistent results and focus on sites with the most favorable outcomes. B. Investigate environmental, demographic, and procedural differences across test sites. C. Standardize test conditions by requiring all sites to follow a single rigid protocol. D. Halt the trial immediately to prevent further inconsistencies. Answer: B. Investigate environmental, demographic, and procedural differences across test sites. Explanation: clinical trials must comply with FDA, Food and Drug Administration regulations and Good Clinical Practice (GCP) guidelines, ensuring data reliability and ethical research standards. Option A is incorrect because cherry-picking results compromises scientific integrity. Option C is incorrect because rigid standardization may ignore essential real-world variations. Option D is incorrect because halting the trial prematurely without investigation wastes resources and delays potential medical advancements. Thus, option B is correct. Analyzing site-specific factors ensures a more accurate understanding of the drug's effectiveness. Question 29. In a situation where resource allocation becomes a major challenge, a government agency responsible for disaster relief finds itself short on emergency supplies due to unexpected demand. What is the most effective immediate action? A. Rely on existing stockpiles and redistribute available resources based on priority areas. B. Increase supplier contracts to secure more inventory for future needs. C. Delay response efforts until adequate resources become available. D. Request emergency funding before taking any further action. Answer: A. Rely on existing stockpiles and redistribute available resources based on priority areas. Explanation: disaster relief agencies must follow FEMA guidelines and emergency response protocols, prioritizing resource allocation based on severity and need. Option B is incorrect because long-term supplier contracts do not address the immediate shortage. Option C is incorrect because delaying response efforts worsens the crisis. Option D is incorrect because waiting for funding approval before acting can cause unnecessary delays. Thus, option is correct. Redistributing available resources immediately ensures the most critical areas receive support. Question 30. During the introduction of new methods where coordination across multiple teams is required, a construction company implementing sustainable building practices faces delays due to misunderstandings between architects, engineers, and project managers. How can the company best resolve these coordination issues? A. Assign a single point of contact responsible for overseeing all teams. B. Require all teams to adopt standardized documentation and communication protocols. C. Allow each team to implement sustainability practices in their own way. D. Hold off on sustainability changes until coordination issues are resolved. Answer: B. Require all teams to adopt standardized documentation and communication protocols. Explanation: sustainable construction involves leadership in energy and environmental design, certification, and compliance with environmental regulations, which require clear communication and process alignment. Option is incorrect because a single point of contact may not resolve the complexity of inter-team coordination. Option C is incorrect because inconsistent implementation can compromise sustainability goals. Option D is incorrect because delaying sustainability efforts goes against industry best practices. Thus, option B is correct. Standardized communication ensures alignment and efficiency across teams.